Good morning, I'm Dermot Graysbrook from Status Staffing, and this is
Michael Bagram from Bagram's Attorneys, and I want to comment on the new labour laws.
fantastic. Thanks for taking time to do that with us, Michael. Do you want to first just give us a bit of context around what happened with the new labour laws, how we got to where we are and what they are?
Sure. Over the last 3 years we've been debating the changes to the labour law. The evils that the labour legislation wanted to cure was the uncertainty that existed between the temporary employment services and the placement of employees, and whether the employees could look to the clients of the temporary employment services for some damages if in fact the temporary employment service disappeared. Obviously the trade unions had other ideas as well, in that they found it was a lot easier to organise at the client rather than the temporary employment service, specifically because the temporary employment service had employees at a whole lot of workplaces, and it became very difficult for unions to organise at the various workplaces. And unions being what they are, they wanted to try and regularize it and actually target one firm at a time, as opposed to a temporary employment service who had 10 people here, 1,000 people there, etc., etc. So those were the two evils that the law was looking at prior to the changes in the labour law. From the 1st of April this year, 2015, April Fool's Day, we saw the implementation of the new law, the amendments, the so-called amendments to the Labour Relations Act, coming into force. These amendments created a little bit of uncertainty in the marketplace, and obviously all of us were going out there to look at the law itself, to try and analyse it, and to try and see how it's going to affect the temporary employment service provider, obviously, and also the client. That uncertainty led to a lot of disquiet in the marketplace, and I think it led to some of the temporary employment services shrinking their own businesses, and the clients asking many questions. I personally, as a labour lawyer, spent months before the 1st of April going around on road shows to various of my clients to have a look at it and to see what could happen in the future. We then had the interesting ruling at the Commission for Conciliation, Mediation and Arbitration. We referred to it the CCMA. That CCMA ruling came out, and it was a very negative one. The ruling, lest them, I'm not sure what they were thinking when they came out with this ruling, they decided that in fact, because of the new law as from the 1st of April 2015, and after 3 months of employment, that employee who had been placed by the temporary employment service, they called it the labour broker, and they're synonymous, the two words, although labour broker in our circumstances in South Africa happens to be a swear word, so we call it the temporary employment service. They said that they weren't the employer. That's the CCMA said, that the temporary employment service was not the employer, and after 3 months the client became the employer, and that therefore if the employee had a problem he had to look to the client only. Now that created absolute havoc in the workplace. Many of the temporary employment services were in shock, and quite rightly so, because I think the judgment was wrong. I think it created more of a problem than the law did in the first place. And second of all, the unions weren't sure what to do themselves. They weren't sure where to turn and who to sue, because in fact, if it is deemed that the client is the employer only, and the client disappears, then you can't look to the temporary employment service, which creates a ridiculous set of circumstances. It's almost Alice in Wonderland. So we as labour lawyers were obviously starting to have a re-look at this, but of course, thankfully, the temporary employment service industry then took this matter on appeal to the Labour Court, well actually on review, and the Labour Court then had a careful look at this, and in having a careful look at this, decided that creates so much uncertainty, it creates so many problems, and it doesn't give the cure that the law was trying to implement in the first place. and it's turned it on its head. What's happened over here now is that the law is saying that the temporary employment service remains the employer for all intents and circumstances after the 3 months, and the temporary employment service has the responsibility of hiring, firing, paying, and in fact taking any action in terms of the Labour Relations Act. However, the one caveat is it does create an extra string to the bow of the employee. The employee can look to the clients if in fact the temporary employment service cannot somehow satisfy the ruling in terms of the Labour Relations Act or the Basic Conditions of Employment Act. So they're saying that the employee now has rights against the temporary employment service, who's the employer, and the client in terms of the new changes to the law. This makes a lot more sense. I don't think it's the end of the story. Don't hold your breath, because we are expecting appeals to that, and we're expecting challenges in the near future again. However, that brings some certainty to the market, and already we're finding in the marketplace the employers taking a deep breath and saying, well, at least we know where we're going as of now. I suspect in 2016 we're going to have more challenges, more fights. All this is good news for lawyers, not very good news for job creation.
Cool. Thank you for that summary, Michael. Just a couple of questions. What was the date that the CCMA ruling happened?
It was around about, I can't remember exactly, I think it was around about July this year that we had the CCMA ruling. They waited for the 3 months, the inflection of the 3 months' time, to show that 1st of April it becomes operative, then you wait the 3 months, and then you say, right, now we want to challenge it. So it was a carefully thought out application to the CCMA. I thought it was quite wise actually, and sneaky, because now what they're doing is they're going to a commissioner and saying the law deems that person, the employee, to be the employee of the client and not the temporary employment service. And I think they pulled the wool over the eyes of the commissioner in this particular case. The commissioner, of course, was looking at the law boldly and saying, well, in this particular case, the client is a much stronger institution than the temporary employment service, so that the client would be able to cure the problems of the employee quicker than the temporary employment service. The real problem we have is that some of the temporary employment services are fly-by-nights. And as you know, some of those people out there were called the Bucky Brigade. They used to take the money from the client, pay the employee less their commission, and then sometimes disappear. And so what the CCMA was doing is saying, let's be practical and expedient. What is better for the employee? I don't think they were correct, but in their wisdom in that particular case, they said it would be better to reside as an employee with the client. And so, to cut a whole long answer very short, the CCMA was looking for the expedient route as opposed to the legal route.
So, Michael, there's some, I suppose, articles have come out over the past few months about the Labour Court ruling on that CCMA case. What I'd like to do is just go through some elements of it and then ask you some questions. So, the decision by the Labour Court on the interpretation of the newly amended Labour Relations Act on September 2015, test case Assigned Services versus CCMA and others, has brought optimism for stability to temporary workers and temporary employment services industry who have witnessed job losses and business during this time of uncertainty. In the context of the job losses and the uncertainty in business, have you had any experience around this? Have you seen business impacted in this way, and how?
I certainly have. The business community is, and I think this is a notorious problem, is quite fickle. Many businesses, and especially smaller businesses, small and medium businesses, are fickle to the extent they're saying that if the law isn't certain, then we're not going to expand. We're not going to create employment. Many of my clients have been emailing, phoning and meeting with us and saying, well, you can't advise us which way to turn in these circumstances. And I kept saying to them, I don't believe the CCMA ruling is correct. And they're saying, well, let's hold on. And if necessary, let's shrink. And they've been doing that. And it's very unfortunate. We've just seen the quarterly figures come out for South Africa. I think it speaks for itself in that we've had a drop. We're probably one of the worst in the world in terms of unemployment. It's the last thing this country needs, to have uncertainty in our labour law. Yes, it's bad to have negative labour law, onerous conditions, and the circumstances around our labour law are not good. But on top of that, it creates a certain amount of uncertainty as well. So that fickle reaction from the business community has been translated into job losses. And we've seen some of the large labour brokers, some of the large temporary employment services, coming out with their latest figures. And we've all seen that in the business day and the business reports. And their latest figures have shown that their clients have put a hold on employment. And they've sent people back. They haven't created new permanent jobs, which is what COSATU, the trade union movement, was expecting. That didn't translate into permanent jobs. Everyone was saying before the changes to the law that if you can't place people temporarily, then obviously the business will have to create a permanent job. Well, that's not how the business people thought. They thought, if I can't have them temporarily because I don't know whether I'm going to get orders in the near future or whether I'm going to get customers in the near future, I'm then not going to create it as a permanent job. I'm not going to take the risk. I'm rather going to shrink my business. So I have noticed that. It's terrible to say it, and I've had my own clients coming back to me saying, forget it. That, of course, for me is it's a crying shame, because I don't have the work then. If they don't have employees, I don't get the work. That's what labour lawyers rely on jobs, because if there are jobs, then there are going to be problems. And if there are problems, then they call me in. And we've had a period now where we've actually undergone retrenchments. I don't think it would be unfair to say that my firm, Bagraham's Attorneys, as a small firm, has been doing more retrenchments in the last year now than we have in the last 4 years, which is horrific. So if you concertina the figures and you have a look at what we've done in the last 10 months, it's equivalent to what was done over 48 months in the past. And it's not that we have had good economic times in this country. So it's been a bad exercise, and it's backfired.
So the uncertainty it brings in the marketplace around TES and who the employee is deemed to be employed by, whether it's the TES agency or the client, the employer, I suppose the
client.
The client, yeah. There's talk about this now being settled. How properly settled is this, and is there any more uncertainty? And it's sort of how hard and fast is this interpretation of this aspect of the new amendments in place? And if so, can HR start developing IR policy and processes around this with the certainty that it's unlikely to change?
I think this judgment came as a breath of fresh air, and I'm hearing already from the clients that, thank God, the Labour Court has now finally ruled on this, and now we can start moving forward and planning our daily bread as opposed to worrying about whether we should employ people. I don't want to be a damp squib. I don't want to be a dampener on the whole exercise. I don't think it's certain yet. I actually have a strong belief that the trade unions are still going to sing. They say it ain't over until the fat lady sings. I think the fat lady's got to sing at some stage next year. Either they're going to appeal this particular case that's sitting at the Labour Court now, and I'm sure they're busy in their boardrooms right now as we speak, looking at it saying, are there gaps here? There was an interesting article brought out by Attorney Paul Benjamin last week saying that the judgment is wrong. Now, he is one of the advisors to COSATU. He wouldn't be writing that and saying that unless his clients had come forward and said,